Time now for the quote of the week. The August 7th Cowichan Tribe's BC Supreme Court decision that's created so much uncertainty surrounding private property rights, including home ownership, got back into the news this week as the Mayor of Richmond, Malcolm Brody, sent out a notice to registered owners. In it, he stated, in quotes, "Please take note that the recent BC Supreme Court decision of Cowichan Tribes versus Canada made some very important decisions which could negatively affect the title of your property. For those whose properties in the area, the court has declared Aboriginal title to your property, which may compromise the status and validity of your ownership." Well, not a surprise that's created this significant stir. On Money Talks back in mid-August, we featured Robin Younger, recognized Canadian expert in Indigenous law. He's the former BC chief treaty negotiator. Well, during that interview, we discussed what may turn out to be a major feature in the court's ruling, and it may come back to haunt us. And that is, while the city of Richmond argued in favor of protecting private property, the BC government did not argue that Crown fee simple grants extinguish Aboriginal title. The federal government had earlier withdrawn that defense, which brings me to the quote of the week, taken directly from the court ruling, paragraph 2086, in quotes. "Richmond advances an extinguishable defense. The province does not. Canada pleaded extinguishment but later abandoned that position," end of quote. That's the ruling. They didn't argue to protect private property rights, which led to the ruling that Aboriginal title is senior interest to fee simple title interest. And as Robin Younger stated, what's worrisome is that the failure of the two senior levels of governments could and probably will be brought up in future cases. In the meantime, the one thing that we know is that uncertainty is the order of the day as the provincial appeal is waiting to be heard.